Happy New Year! Let's talk about punitive damages. Specifically, does English law have punitive damages? Spoiler, sort of, but it gets complicated. And should that be the case? Or should it even be extended? So what I need to do first of all is just explain about damages generally. And this will be quite useful to anybody who gets embroiled in any form of litigation, because, obviously this is a major thing, isn't it? When you sue, you are effectively suing for damages. So what do I mean by damages? Damages is just what we mean. It's how we refer to the sum of money that will be awarded in compensation if you are successful in your claim. And that's the first thing to sort of bear in mind. That in civil law, generally speaking, it's all about compensation. It's all about putting things right. It's not about punishing people. That's not always been the case, though, and I will come on to that. But at common law, damages is the only remedy. That might seem a real bit weird, but that's literally all that the common law can do. Somebody does something wrong, whether it's a breach of contract, a negligence claim, a defamation claim, a personal injury claim. All the common law courts can do is say, here's some money to make up for that. And the idea is that it's a sum of money that puts you back into the position as if the wrong had never occurred in the first place. Now, that could be sort of straightforward in a financial matter. Let's say it's a breach of contract. Well, had the person not breached this contract, your financial situation would have been this, but they breached the contract, so your financial situation is now this instead. So the damages are the difference between the two situations. But even then it gets complicated, because, let's say it is a breach of contract. You engage somebody, you contract with somebody to provide some goods and services or something like that, and they fail to do that. Well, what's your loss? Well, there are several ways you can look at it, really. Let's say you were going to buy a load of goods and sell them on. You're going to buy a load of, you ordered a load of t-shirts to be printed up for a concert. You're going to sell them at the concert. And they don't provide those t-shirts. What actually happens, though, if the concert gets rained off or something like that? Well, actually, you wouldn't have been able to sell those t-shirts. You'd have been stuck with them. However, you can still sue. And in that case, you'd just sue for, you'd want your money back. Say, well, I gave you this money to give me the t-shirts. You didn't give me them. Give me my money back. But what if you could argue and say, well, the concert would have gone ahead. I'd have sold out of all these tickets, all these t-shirts. And here's the profits I would have made on that. Well, you can sue for loss of profit. You say, well, had you have delivered these, I could have sold them onwards and I would have made a fortune. So your damages there are the loss of profits. And what you will do is you will always sort of seek to sue under the head of damages that gives you the maximum return. I mean, with IP, for instance, a breach of copyright, you've got several ways of suing there. If somebody infringes on your copyright, you've got three ways. You can sue them for any profits that they made using your material. You say, well, you sold all these fake things of mine, therefore just give me the money you made on that. You can say, actually, you putting your things on the market undermined my legitimate sales of the real items, so I'm going to sue you for the losses that I incurred because I didn't sell as many real ones because the fake ones were out there. Or you can just say, I will sue you for the fee I would have charged you to license these IP rights to you. So you can see already it gets quite complicated, even on something as simple as damages, as just monetary damages. We also talk about the difference between general damages and special damages. Special damages are ones where you can actually point to figures and say this is, this is a financial loss that can be calculated. Whereas general damages are more sort of, as the name suggests, just general compensation. The best example of that is personal injury. I mean, say somebody like, chops your arm off. Now, you might argue and say, well, no damages could ever properly compensate me for that. I'd rather just have my arm back, thank you very much. Well, that's not going to happen, is it? But it's actually, quite established how we calculate damages. There's various books. There's one called Kemp and Kemp that lists every conceivable type of injury that can occur to people. And you go through and you identify it and say, well, the loss of a finger is this, a broken elbow is this, And it covers things like scarring. And what's interesting there is the amount of damages you get. It depends. If you're some sort of top supermodel and you get a facial scar, you get more money than, like, if it was me. Because, if I get a facial scar, people are just going to go, well, yeah, it's hardly ruined your modelling career, has it? In fact, it actually quite looks cool. But you calculate all that, you can add little bits together. I mean, you can't double recover. It's like somebody, chops your finger off and then chops your arm off. It's basically, you don't get the finger and the arm, you just get the arm. And it's all calculated for sort of changes in the value of money, the RPI. And you come to a figure like that. So that's a very sort of general thing, obviously, as the name suggests. But, you get your general damages for pain and suffering and the loss of amenity in that you've no longer got that arm. But then also it might be things like, well, you've injured me now and I've had to modify the house. I've had to have my car modified because I can't change gear anymore. And, that modification has cost this much, or I need a ramp in the house, or I need the house making more disability friendly, or I've needed to go for physiotherapy and I've gone private. Because that's one thing, actually, when you get personal injury, although there's something called a duty to mitigate your loss, which I'll come on to momentarily, it's not an absolute, so people can't say, well, you could have gone on the NHS. It's like, tough, I'm going private. And you could put the bills in for that, can't you, and say, these are the invoices from the physiotherapist. So that's your special damages, and you add them all together. Now, what about mitigating loss? That's an unusual feature of English law, and this comes back onto the punitive damages aspect, is if somebody does something wrong to you, you can't just sit there and go, great, I'll just coin it in. You've got to sort of take reasonable steps to actually mitigate your loss, to sort of lower the amount. So let's say, for instance, I've got an oil tank outside, and somebody bumps into it and they knock the tap and all the oil's leaking somewhere. Well, yeah, they've done wrong, and I can sue them for all the oil that disappears. However, I can't just sit there and let it all drain away and sue them for the full amount. If it's easy enough for me to either turn the tap, or let's say it's broken, it's easy enough for me to get a spanner out and just somehow stop it. I am expected to do that. And this is something that people argue a lot in sort of damages claims. They'll say, oh, you failed in your duty to mitigate your loss. So yes, we accept we're responsible for this bit, but we're not responsible for that bit. And this can sometimes cross over with things like contributory negligence. That's failing to mitigate your loss in advance, sort of. It's like, yes, I ran you over on your bike, but you weren't wearing a cycling helmet. And yes, there's no law says you have to. However, it's not unreasonable to expect people to wear cycling helmets. So I'm not paying for any head injuries you got. Because had you have worn a cycling helmet, you wouldn't have suffered those head injuries. And courts, because they try to encourage people to sort of, make things as safe as possible, they will usually allow a deduction there for contributory negligence. Same if you're not wearing a seatbelt and you're in a car accident. I mean, the theory is they're supposed to identify and say, yes, specifically you not doing this. That's why you've got these injuries. But sometimes you can't exactly work that out and say, what's the difference? What would the difference have been between wearing a seatbelt or a helmet and not wearing one? So they'll pluck an arbitrary figure out, 15%, 25% or whatever, and just reduce the damages that way. Sometimes we have something called liquidated damages, where you agree what the damages are going to be in advance. This is something that crops up a lot in, say, building contracts. You'll have a liquidated damages section. Because, again, we don't allow punitive damages generally. Although I will come on to that, I promise, because I know this is meant to be a video about that. But it's more a video about damages generally. I just wanted to catch it intro. So what you'll say is, okay, this contract, I need this building work done by this particular date. And for every day you are late, I will claim liquidated damages in a particular sum. Now, again, you can say you can't use them effectively as punitive damages. You can't say, I want £10,000 a day for every day that you are late doing this. It's usually in the hundreds of pounds, because the idea is that it's meant to reflect a realistic estimation of your actual losses. You don't want a situation where somebody's actually hoping that the builders are late with something, because then you're better off. But what if there's a very interesting thing, and this crops up a lot with the car parking stuff, and this was the famous parking eye case. Let's say, for instance, you're in a car park and you are in breach. You either don't buy a ticket or you overstay, or you don't park within the lines or something like that, and you get your fixed penalty. Because like I said, they're not fines. People say, I've got a parking fine. They're not. They're just claims for breach of contract. And if you don't pay them, the parking company have to sue you, and they have to show the loss. And they did that. Now, what people argued and said is, well, hang on, what is your actual loss? So let's say I park in your car park and I don't pay. What have you actually lost? Well, arguably, you've just lost my £2.50 or whatever it would have actually cost me to park there. Because, okay, I've blocked a space off and I've used it. But what if you overstay or something like that? What's your loss? Well, you were staying in that bay when, you hadn't paid for it. Yeah, no, but what's your loss? It's not like the car park was full. So you didn't lose out on anybody else coming in because they could have just parked next to me. There was loads of spaces here. And what's interesting there is the court said, they said this is an unusual case because Parking Eye's entire business model relies on people breaching the contract. If people just abide by the rules, they make nothing. They make nothing whatsoever because they don't get the parking money. They just get the penalty notice fees. And people were arguing to say, well, you haven't been able to show there's actually a loss there because, unless I took the last space in the car park and so nobody else could get in there, there's no loss. And even if there was, all you've lost is somebody else paying £2.50 an hour or whatever it is to pay there. But what the court said there is, yeah, this is sort of breaching against how damages normally are compensated. But we can see that they need to enforce their parking rules. So what will allow them to do is to average out the cost of enforcement over all the people they have to claim against in a year. And they accepted the figures and sort of said, actually, well, yes, on average, it costs about 80 quid per person, per person they claim against to actually monitor the car parks, even though there was clearly a profit element built into there. They were saying, well, clearly it doesn't because it's not like they're breaking even. But the courts there said, okay, it is going against the rules, the general principles a bit, but we will allow that. So that's quite a controversial decision. But without that, they said, Parking House said, well, without that, there's no point. We can't operate. And some people said, well, good. Maybe you shouldn't be able to operate and people should just have to sue for and just claim what they actually lost like everybody else has to do. But they did uphold that. Like I say, you've got your sort of general damages and your special damages. I mean, like defamation's an obvious one, isn't it? It's like, what is your reputation worth? Well, we'll just pluck an arbitrary figure out of the air. I mean, it's weird how usually in defamation, we can usually predict what the compensation's going to be. But that's literally just by knowing what recent decisions have been. I mean, the law of defamation isn't particularly complicated. I mean, I've done loads of videos. Hopefully they're fairly easy to understand. I mean, I could take you through everything you need to know about defamation law in like a weekend or probably even just an afternoon. But defamation is one area where you're just paying people to anticipate how the judges will apply the law. Not what the law is, but how they will apply it. I think a judge is likely to find this is a matter of opinion. I think a judge is likely to find this is in the public interest. Okay, I find the judge is likely to find this is defamatory, and the judge will say these are the levels of damages that is appropriate. I mean, it's a lot easier now. Now we don't have juries in defamation claims. But yeah, so like I said, the starting position is damages are meant to be purely compensatory. They put you back into the position as if the wrong had never occurred. However, from about the sort of 1760s, they did introduce the concept of punitive damages. They said, look, we want to discourage people from ripping people off and doing wrong things to each other. So I don't see why that shouldn't be taken into account when we're awarding damages. We want to discourage people from behaving badly in life generally and business in particular. Although, interestingly, you could never claim punitive damages in contract cases. However egregious the breach may have been, you could only do it on the calculated loss stuff that we've just been talking about. But then that sort of faded away a little bit in the 60s. They said, no, well, look, the criminal law is there to punish people. The civil law is just there to put people back in the position they were. And bearing in mind, we've got all these rules about mitigating your loss and things like that. The idea is that it's almost sort of to protect people who do wrongdoing. Because, most stuff you sue for, by definition, if you sue for negligence, you're not really suing for something somebody did deliberately. It's something somebody did carelessly or accidentally. So it's like, should they be over penalised for this? when people can take reasonable steps to protect themselves. However, there are a couple of situations. Now, we don't actually use the word punitive damages. We talk about things like exemplary damages, aggravated damages, things like that. Aggravated damages crop up quite a lot in defamation. Because defamation is one way, it is effectively, it's all about vindication. The idea is that you get so much money so you can point to it and say, that's the court marking how wrong that person was about me. I mean, theoretically, there is a way, actually, where you can say, I'm suing because I say somebody said something wrong about me. I'm not even bothered about the money. I just want the record putting right. And you can go for a declaration of falsity, because courts can do declarations. But, like I say, that's how if common law only allows damages, financial compensation, how can you have these other remedies? Well, they're all equitable remedies. So things like injunctions, restitution, stuff like that. These are equitable remedies where they're not just financial. I mean, and now we have the two parallel legal systems. We have common law and we have equity, but we no longer have the separate courts. We used to do until between 1873 and 1876. We had some things called the Judicature Acts, and they got rid of the separate equity courts. But they said, we'll just have one court system, but it can apply both rules. So that's quite useful. I mean, say somebody like nicks something of yours. The civil version of theft, it's sort of called conversion. You sue for conversion or trespass to goods or something like that. But theoretically, all the court can do is say, right, you have nicked this thing off somebody. It's worth money. Give them the money. But you couldn't sue and say, no, I'm not bothered. I don't want the money. I want my thing back. Now you can actually do that. Now, we still actually call both versions conversion. We still say, I'm suing in conversion. I either want my thing back, or if you can't get it back anymore, it can't be recovered, I want the money compensation for the value. Some jurisdictions, they talk about the actual suing for the money is conversion, but saying I want the thing back, you're suing replevin. And unfortunately, that's not a word we use over here. It's not a cause of action. I have had a look to see if there's any sort of bar on pleading replevin in this country. I don't think there is, because I've always wanted a case where I can just say, and we are bringing this claim in replevin, because I just think it's a great word. And it's one that crops up a lot in art law, when people try to recover stolen art or looted art and that sort of thing. So replevin is a very popular cause of action in other jurisdictions when it comes to artworks. So there you've got all your sort of various ways. So it's like, I want the money back, or I want some non-financial remedy, so like restitution or something like that. That's another way of putting you back into the position you were beforehand. But if it's something like somebody nicked your thing, the best way of putting you back is to return the thing. But the truth of that is, you say, well, hang on a minute, it was worth them nicking it, because forget, whether the criminal courts get involved, but just from a civil point of view, what's how do we discourage people? Because it's like, well, I'll nick this thing, and the worst thing that's going to happen is I'm going to have to give it back if I'm caught, so it's worth doing. So that's where the idea of aggravated damages comes in. And that's where it's to mark, effectively. There's two times we bring these in. Sometimes you get aggravated damages where you are suing a state actor, a government body or something like that, like the police, for instance. I mean, the case that actually brought this all to a head, I say recently, in the 60s, it was one where a police officer had forged basically something and framed somebody. And they said, well, okay, in terms of the damages, it was actually sort of sorted out relatively quickly. It wasn't a very sophisticated fraud. And yes, it must have been horrible for this person to feel that they were, at risk of, jeopardy, as our American friends would say, going to prison. But in the end, it was all sorted out. So what's their actual loss? And the courts there said, no, that is so egregious, having the power of the state against you, that we need to mark that. But they don't really talk about in terms of punitive damages. They just say it must be worse. In terms of general damages, your pain and suffering and hurt feelings, it must be even worse that you think that you are being framed by the full power of the state. So therefore, it's not punitive damages. We're just saying the damages should be increased because you were in a particularly horrible situation. So that's category one. However, the other category, and this is where we get into punitive damages, and I'll just read the rather nice quote. This is from Lord Nichols. From time to time, cases do arise where awards of compensatory damages are perceived as inadequate to achieve a just result between the parties. The nature of the defendant's conduct calls for a further response from the courts. On occasion, conscious wrongdoing by a defendant is so outrageous, his disregard of the plaintiff's rights so contumelious, should have rehearsed that something more is needed to show that the law will not tolerate such behaviour. Without an award of exemplary damages, justice will not have been done. Exemplary damages, as a remedy of last resort, fill what otherwise would be a regrettable lacuna. And what they said there was, this is to cover situations where people have calculated and said, it's worth me doing this because even if I am caught out, well, if I'm not caught out, I'm in profit anyway, but even if I'm caught out, the amount of damages that I'll have to pay will be less than the profit I might make. Now, the classic example of this, it's in Ralph Nader's book, Unsafe at Any Speed, where a car manufacturer realised that their vehicles had a particular fault on it. To remedy the fault, they'd have needed a recall. And it would have cost, they'd had to replace a part that cost about $11, but they would have had to go through all the recalls. So they had to recall hundreds of thousands of cars. And they worked out and said, well, look, statistically, we're only going to kill about 10 people a year because of this fault. And the average payout, if we just admit it straight away, no admission of liability, but we'll pay the compensation straight away. Actually, it's cheaper to do that than it is to fix the fault. So we'll just do that. We'll put in the budget. We'll kill about 10 people a year. We'll have to pay them out about $500,000 each. You know what? $5 million as opposed to $20 million to recall and refit. Yeah, let's do that. And that did create a bit of a scandal, as you can imagine. So the idea was that actually, no, we need to discourage people from making that sort of calculation. And that's where punitive damages comes in. And like I said, they're still very rare in this country to award punitive damages. I said we don't call them punitive damages. We will call them something like aggravated damages. Because, we want to get away from this idea that the civil law has any sort of, role in enforcing behaviour or enforcing conformity. It's just meant to be putting things right. The criminal law does all that sort of thing. So, but this is one time when you can get punitive damages, where you can say, these people made such a calculation that it was such a cynical thing to do. I mean, this happens a lot in defamation, where it's like, well, this is such a juicy story that we'll sell so many extra copies on the back of this story. Even if it turns out that it's not true, the actual libel damages will be less than we'll make selling, extra copies or put it in our Sunday magazine or something like that. So that's where punitive damages actually comes in. But like I say, it's still quite a controversial topic in civil law. Because we talk about, what is meant by calculated conduct, for instance. And this is Lord Justice Rick said, controversial as punitive damages are, they are not to be contained in a form of straitjacket, but can be awarded ultimately in the interests of justice to punish and deter outrageous conduct on the part of the defendant. As long, therefore, as the power to award exemplary damages remains, it is not inappropriate, in a case such as this, where the claimants have been persistently and cynically targeted, that they, rather than the state, should be the beneficiaries of the court's judgment, and that a defendant's outrageous conduct should be marked as it has been here. They are truly victims, and there is no question at all of the award becoming a mere windfall in their hands. Because that's what they were saying, you see. They're saying, like, well, even if the criminal law comes in and says, you will be sent to prison and we'll come after you for proceeds of crime, the victim doesn't get that. The victim doesn't get the compensation, the proceeds of crimes. You've ripped these people off and you've benefited to this. You shouldn't be allowed to keep that money. But it just goes to the state, it doesn't go to the victims. So the argument there was, well, hang on, that's not really fair, is it? Because, if somebody's going to get a windfall here, it's just the state and not the actual person. And they said, provided that it is recognised that the criteria which Lord Devlin identified, that was the bit about, it's either, it's got to be so egregious, etc., or it's got to be an abuse of power, that the wrongdoers calculated that the profit to be made from the wrongdoing may well exceed any compensation he has to pay the claimant, must have been satisfied for exemplary damages in the second category to be available. This seems to be an appropriate statement of the approach to be adopted to the award of exemplary damages in this category. So there you go. So they emphasise that it's the wrongdoing that's being punished. And interestingly, that's moved on a little bit now, because they've sort of said that should be we look at the behaviour, not the outcome. Because originally it was, well, how much have you profited by? And that will trigger exemplary damages. But now they've sort of said, well, actually, no, we look at the conduct. So even if it was an ill thought out scheme, or it was a scheme that just failed, or it was nipped in the bud very early, it's not a defence to say, I shouldn't have to pay exemplary damages because my plan was rubbish, or I shouldn't have to pay exemplary damages because you caught me very, very early on. The idea is that it is effectively, performing a deterrent role. So there you go. So that's like a sort of a brief history of damages generally. But this will be like I say, if you're ever embroiled in litigation yourself and you have to sue somebody, you can think about things like this. How do you calculate the damages? Somebody messes up, you book somebody to build you a kitchen and it all goes wrong. Well, do you just want your money back and then instruct somebody else? Or do you want them to an order that they have to finish the kitchen to the standards that were in the contract? Or do you say, well, I'll get somebody else to fix this, and you should pay for them putting it right? Pick one. So it all gets sort of quite complicated. But there you go. Hope, as always, you found that vaguely interesting, vaguely useful, vaguely accurate. It's nice to be back. The weather's picking up a little bit, so hopefully I'll be outdoors soon. I was going to risk going outdoors again today, but I've got still got there's been a big lurgy going around down here. So we all went out sort of pre-New Year, sort of all like just celebrating and seeing each other, and for some reason just everybody came down with like the plague. So like New Year's Eve down here was everybody going, no, I'm not coming out, I don't feel well. So I was very tempted to go out, but I've just been going for some nice gentle walks. I was thinking about getting out and doing all myself on the cliff tops with the selfie stick, but it would have been like, back to coughing and wheezing. But I'm pleased to say I am feeling a lot better. And like the voice say, Happy New Year. And somebody said I looked like a Bond villain in my last video in that shirt. That's the shirt that the lovely people in Sierra Leone had made for me, which I really like, not least because I've got really orangutangy arms. That's the only shirt that actually fits me. So there you go, right? And now to get across and do the thumbnails. So I'll have to sort of say to Dan and say, oh, hi Dan, Happy New Year. Oh, by the way, can you do me a thumbnail, please? There we go. So that's one look. More of, by the way, he's a capybara. He's a capybara, or a parchinko, as they call him in Argentina, which actually means grass dude, which is possibly one of the coolest names ever for an animal.